in that case.
Yep, that's a 5 now.
Good morning. My name is Paul Crescent. I'm a reporter appointed by Scottish ministers to report in relation to the Orkney Islands Council Scapa Crescent Kirkwall stopping up order made by the council. This is a pre-examination meeting in relation to that order, and in the course of this morning, we will be considering certain procedural matters relating to the order that's been made. I'll ask people to introduce themselves around the room in a moment, but just before I do so, I'll just say a little bit about my role and who I am. As I say, my name is Paul Crescent. I'm appointed by Scottish ministers to report to ministers. I was appointed on the 16th of May to prepare a report into the justification for and the objections to the stopping up order. 4 objections were received within the appropriate timescale, and my report in due course will be intended to inform a decision by ministers in relation to the order as to whether to confirm the order, to refuse to confirm the order, or to confirm the order with modifications. My role is to gather the facts and make findings and recommendations to ministers to inform their decision-making process. My intention in relation to this meeting and in any subsequent oral procedure that we have is to make the procedures as informal as is possible in the circumstances. This is a formal process in one sense, but in order to try to ascertain, as well as I can, the issues arising, I would hope I can make it as informal as possible, and I appreciate that particularly as far as the objectors that are present today, it's very likely that this is an unfamiliar process and procedure to them, and I recognise that you'll not be familiar, or probably not familiar with processes of this nature, and so I would encourage you today or at any subsequent calls that we have very much to speak up if there's anything that you're not understanding or anything that you feel in any way uncomfortable about, and we'll try and ensure that you can be made comfortable, or as comfortable as you can be, in participating in this process. As you know, this is described as a pre-examination meeting, and so, as I say, the purpose of this is to deal with certain procedural matters that are necessary to help me go about my task. There's no expectation that any evidence will be led today. There'll be a later process and opportunity to do that. The meeting this morning, as you know, is being webcast and is being shown as we speak, but will be available later on for access to the DPA website. So you shouldn't feel the need, as I'm not going to feel the need, to take extensive notes as I'm going through, because you can go back and look at this by going onto our website if there's anything that you need to recall or anything that happened at the meeting you wish to view again. For GDPR and data protection purposes, your participation is presumed to be consented to by joining the call today. So the process today, as I say, you can look at this again, but what I will do after this meeting is send a note of various outcomes from today, so that parties, including those who are not on the call, can see what's been decided and agreed, even if they're not watching as we speak, or if they don't watch at a later stage. So that's all I wanted to say by way of general introduction for the meeting. I'll maybe ask parties to introduce themselves, starting with the council just in a moment, to say who they are and ask any questions they have about the procedure set out for today or later on. For the objectors, it'll be useful when you introduce yourself to say whether it's intended that when we get to later oral procedure, you're intended to be represented, whether by a lawyer or not. There's no need to be represented by a lawyer for these processes. You're entitled to have legal representation, but you shouldn't feel obliged to have that. But also, if you intend to be supported in later procedure by anybody else, a friend or whoever, who you might want to accompany you to later proceedings, then that's absolutely fine as well. But if you could indicate if that's what your intention is at this stage, then that would be useful. So I'll maybe start. I think we have Paul Maxton and Jamie McVicker from Orkney Islands Council, and I would be asked them to introduce themselves first of all. Thank you.
Good morning, everyone. Yes, Paul Maxton from Orkney Islands Council, solicitor.
Jamie?
Yeah, good morning. I'm Jamie McVie. I'm the service manager in development management.
Oh, thank you. And I think it's Stephen Russell. In emailing, I think you're Stephen. You're representing Tracy Russell, and I assume Margaret Anderson as well from the Childminding Service. Apologies if that's not your first name. You were just described as Mr. Russell to me, so I'm assuming from previous papers that you're Stephen Russell. But is that right?
Hi, yes, and I'm representing Tracy and Margaret.
Okay, thank you. And Fraser. Not hearing you yet, Fraser. Can you hear us? Right, not. If you're having difficulty in contacting us through the microphone, if you could either put your hand up or put something in the chat bar, perhaps, Fraser, and we can work out where we go from there. Oh, I just get the list of participants. Yeah, so I see a hand up, Fraser. So it doesn't sound as if you're able to communicate with us, but it looks so you are here. I don't know if what you want to do is try and go out the call and come back in again, and see if that's better. And in fact, I'll just see something in the chat bar as well. So if you give me a second. Yeah, he seems to be leaving the call just now. It indicated he seems still to be on mute. I'll give him a second, then we can hopefully get him come back in again. I take it Fraser hasn't come back to you suggesting he's come back in yet.
No, I've not got anyone, not got Fraser joining in the lobby just yet. I can email him if he's not here in a couple of minutes.
Sure, thank you. I don't know if you want to try and email him actually, and maybe we can just sort of adjourn for a couple of minutes till Fraser comes back, rather than have people sort of just sitting waiting for him.
That's strange. I'm just sending an email.
If you can try and email them, then we can obviously switch our cameras off, and to keep the sound on, I'll watch the screen then, and then you can maybe do other things rather than sitting waiting. So we can just adjourn for a couple of minutes, but I'll keep my eye open, and if you could as well, Callum, for Fraser coming back in again. Thank you.
Hi, Fraser. Just checking if you can hear me okay?
Yes, I can hear you.
That's perfect. Thank you.
That's all fine. So hopefully others can maybe just rejoin the meeting. As we have Fraser with us now. We just stepped out of the meeting for a second, Fraser, while you were going back in, but delighted to be able to rejoin us and to speak. So others will just be joining us and switching the cameras on, hopefully, just in a second. And so fine, we all seem to be doing that. Fine, I can see Paul again. Go back in. So we're just going down, Fraser, just effectively introducing ourselves. And I think you have an interest as the owner of the Orkney handcrafted furniture outlet. So I think that's your interest there. And if you just introduce yourself and indicate, if you can, whether you're intended to be represented in some form at any future oral procedure. Thank you.
Hi, I'm Rich, and I'll be representing my business, Orkney Handcrafted Furniture.
I circulated a suggested agenda for shaping discussion at today's pre-examination meeting. I've had no suggestions of any amendments there. If anybody has any additional items, as I say, we can speak up as we go. But if there's anybody who has anything that they wish to add, and it is sensible to mention at the start of the meeting, please say so just now, or indicate one way or other which feeling I'd intend you to proceed this morning based on the agenda as previously circulated. On that basis, as I say, item 1 on the agenda is identification of the objectors who wish to participate in oral procedure. As we know, we have Stephen on behalf of Tracy Russell, Margaret Anderson and Fraser Anderson on the call today. We've had an email from Anne Rendell, who is the third objector, who does want to maintain her objection, but has indicated that she does doesn't intend to participate in any of the procedures that are going to follow from this, and she is resting on her objection. And the fourth objection is from a William Flett, who we have not had any communication from as to whether he wishes to participate in oral procedure. We'll continue to work on the basis that we'll send him information, including in particular the invite for this morning's meeting, although obviously he's not attended. So we're working on the basis, and I'm working on the basis that he's maintaining his objection and have an opportunity to participate at later stages as necessary. I should emphasise, as I did when I wrote to you all on the 24th of May, that objections that have been received will all be given equal weight and will be carefully considered by me, regardless of whether you choose to participate further in oral procedure or submit further statements of case or not. They'll all be treated equally. So that's my understanding, and unless the council have any different understanding from that, that's the basis of which I'm proceeding just now. I'm saying north from Jamie, so I'm assuming that's the case for that. Moving on, item 2, although items 2, 3 and 4 I suspect actually will kind of coalesce into each other to a certain extent. The first issue as to whether parties have any representations to make as to whether I should proceed by a hearing or by a full public inquiry. I'll explain the difference between those in a moment. As it indicated in our letter, I'm minded to proceed by way of a hearing, and the council are of the same view. We sent a link to the parties of the differences between a hearing and a full public inquiry. A hearing is a bit less formal and is a discussion which is led by me as the reporter, having identified key issues that require to be discussed. And that questions would be asked primarily of council witnesses, but it could be of all or any participants and their witnesses, of issues that are relevant to the question before me and before ministers. Strictly, questions from objectors would be channeled through me as chair. As it turns out, I generally tend to run hearings in a fairly informal kind of way. If objectors have any questions they want to pose to witnesses, as long as they're kind of sensible, relevant and polite, then it tends to be a fairly informal process in my experience. The formal full public inquiry is more like a kind of court type process, whereby witnesses are more formally led on behalf of different parties and present their evidence, which is then cross-examined and potentially re-examined by objectors and indeed by me if I have questions. It doesn't appear to me that the circumstances arising in this particular order necessitated a full public inquiry. So, as I'd indicated before, my intention to proceed by a hearing. But I wonder, I've invited Stephen, first of all, then Fraser, whether you have any views or you want or anything you want to say on that particular point at this stage. Stephen, first of all.
Right, no, I think a hearing would be a good option. Happy with that.
Okay, that's helpful. And Fraser?
Yeah, I'm the same.
Yeah, okay, that's fine. Thank you for that. The next related question as to whether parties have any preference as to whether the hearing should be an in-person hearing or a virtual hearing. I'm anticipating, obviously, a little bit ahead of what we hear from the extent to which parties want to lead evidence and have witnesses, that the hearing, I'm probably thinking about a half-day hearing as being the duration that's necessary for this. The question in my mind is whether parties have any preference as to whether they would rather have an in-person hearing somewhere in Kirkwall, very possibly if it's okay on council offices. But if there's a preference to have it on a more neutral venue, that could be done as well, or alternatively on a virtual basis. It does tie into the question as to the site visit, because if I have to do a site visit by coming to Kirkwall, then that might point towards the suggestion that we have an in-person hearing, is slightly old school pre-COVID style at an appropriate place. But again, I perhaps invite parties. I should say that I've looked at maps and looked at streetscape views of the site. I've never been to Kirkwall, so I can't claim any knowledge of the area particularly, but I'd maybe invite views, starting with the council, on those two related questions as to whether they refer the hearing to be in person or virtual, and what their views are on the benefit or need for me to attend a site visit in person.
Yeah, I'll
Sorry, Jamie. Yeah.
first there. I've got a wee bit of an echo coming through, but yeah, I mean, we don't have a stated preference. I think it's just at reporter's discretion, whichever you think was most appropriate. The site is generally unchanged, and Street View has a relatively recent view of the site, so there's no change to the network of the road since that's been done, and you can see the site itself that was the subject to the related planning application. So there's certainly no preference for it to be in person or for a site visit, but equally no objection should you be minded to do so.
Okay, turning next to Stephen, I wonder what your views on that are. And I'm conscious here, again, without going into the detail of the nature of your objection, from the childminding business, one of the issues in relation to the objection is to do with safety and drop-offs and the like. And I know any site visit would be looking at the position now, not looking at the position, obviously, when the development is completed. But I don't know what your preferences would be in terms of both those questions.
We would have an objection either way for the actual hearing itself, but I do feel it would be beneficial if you did come on a site visit, because you can actually see the proper layout of the road. You can actually look at how busy the main road is off that section of road, and you can see how much safer that little section of road is. So I think you would actually benefit by coming on a site visit. But in terms of the meeting itself, I don't mind which version.
Okay, that's helpful. And Fraser?
I'm the same. I think a site visit would be my preference, purely due to the fact of my business, where it's at, as far as my customers visiting, and just the actual layout of the road. And as far as the meeting goes, I would prefer it to be in person.
Okay. No, that's very helpful. And if I do come up, obviously, then it makes perfect sense to do it in person from that perspective. Does either Fraser or Stephen would have any objection to being held on council premises? Often these hearings, we try to make them on a neutral venue. And I think we'll probably try to do that somewhere in Kirkwall, but I've no sense as to whether there are facilities. Obviously, there's not going to be a lot of participants. What the facilities are like in hotels or other public halls or places. So I think we'll endeavour to have it on a neutral venue. But if either of you have any particular kind of difficulty or objection to using council premises, assuming the council are willing to let us use the premises, that is, just let me know.
Real objection either way, but neutral sounds good, I think.
Yeah. Okay, that's helpful. That's good for that. As I say, that kind of effectively sort of covered reasonably quickly items 2, 3, and 4. I was actually going to go, in fact, rather than going on to item 5, to skip that, just do it slightly out of order, and look at item 6 on the agenda. And the reasons for that will become obvious in a minute why I want to do that. And that is the issues of consideration by ministers. This may be a question really for Paul at the council, as much as anything else. I've got a couple of issues, actually, none of which I really am expecting an answer from you now. If you don't have the answer, if you have the answer, that's fine. But there's a couple of issues that I've been looking at in preparing for this meeting. Now, there's sort of a couple of top line issues and a couple of more minor ones. But the issues in my mind, and this is just sort of a factual narrative question to start with, is I see that the powers that are being cited for the order refer to Section 207 of the Town and Country Planning Scotland Act 1997 and not Section 208. As you'll know, Paul, Section 207 deals with the topping up of a road, and Section 208 deals with the topping up of a footpath. Obviously, only Section 207 is cited. I'm presuming that either there are no footpaths in that area, or that there's no need for a footpath to be stopped up in that respect. I make no qualitative comment about that. I just observe that the council have cited as their power Section 207, and therefore the only thing that's sought to be stopped up is the road and not associated footpaths. You don't necessarily need to comment on that, but I just make that as an observation, and I presume that's what the intention of the council is.
Yeah, that's my understanding of the position, reporter. Yeah, I don't know if you've got anything to add to that, Jamie.
Yeah, that's correct. It's the road that would be stopped up, but the existing footway that runs to the north of the area to be stopped up, that existing footway would be retained.
Excellent. Okay, thank you for the clarification. The second issue is that question about the test under Section 207, is that it's necessary to show that the council are satisfied, and where objections take place, that ministers are also satisfied as to the test under Section 207 that it's necessary to stop up the order. That, of course, is not the same as the granting of planning permission. Looking at the statement of reasons, a bit of a question the council might want to just reflect on as to whether the justification, the necessity test of that, which is not met by the grant of planning permission in itself, can support the justification. I'll need to be satisfied in my report to ministers that the necessity test is met, and it's a required consequence because of the development for the road to be stopped up. I don't know whether it's intended by the council to lead evidence at the hearing to that effect, or whether they want to supplement that in a further statement of case that's being put forward. Paul.
Yeah, I mean, I think that's something that we can look into in more depth. You know, obviously, is the council's position that the order is necessary, and we will be providing evidence to that effect. We will review whether we consider whether further supplementary evidence by way of recognitions or whatever is required as a consequence of that.
Yeah, I mean, that's helpful. I mean, I'm thinking here of fairness to the objectors. I mean, one of the things that I was going to come on to a bit later on in terms of how we deal with the procedure, and I appreciate the council are more familiar with this perhaps than objectors are, is that there should be no surprises and no ambushing in argumentation for my benefit as much as the other side's benefit. And so my expectation at the hearing is that I'll not be presented with new evidence or new arguments for which notice has not been given to all objectors. So you might want to reflect on the extent to which that case in, as you say, preconditions or any further documentary evidence is set out. But as I say, it will be required, I think, for you to satisfy ministers as to the justification for the order based on the meeting of that necessity test, which, as I say, is not met by the grant of planning permission as such. It's a separate test, albeit under the same act. So that's something to reflect on as we go forward. Moving on, I've seen the evidence in relation to public notice and the like. It'd be useful actually if you could confirm, not necessarily now, the date in which the adverts were placed in the Edinburgh Gazette and the Orkney. I see that you've lodged the advert with the closing date for objections. It'd be quite useful if you confirm the date it was in the respective newspapers. But I'm assuming that the land around there is all owned, including the soil of the land, is all owned by the council, or otherwise that notification under Schedule 16 of the 1997 Act has been given to everybody with an ownership interest. I'm not sure I've quite seen that from the records of documents submitted to me. So again, in the course of the period ahead, maybe you could just confirm the land ownership position. As I say, I'm taking it that the land concerned is, and Solom is all owned by the council, but purely in terms of notification or intimation of the intention to make the order, that's all been satisfied. So you might want to again note that. I'm assuming again that Scapa Crescent is on the list of adopted roads of Orkney Island Council. That's just for form's sake. And I assume also from reading the report of the committee and also a quick look at a map of Kirkwall, I'm assuming that Scapa Crescent falls out with the Kirkwall conservation area. It looked like it did from the plans, but obviously there are different responsibilities in relation to the stopping up and the impact on the conservation area and its setting. But again, if you may just confirm that to me at an appropriate time in the course of things going forward. And the last kind of procedural point, I think it would be quite useful for the council, just on the basis of the justification, is I've seen that your roads department are in favour. It would be quite useful if you were to indicate or produce the results of your consultation with the emergency services, just so I could be satisfied that the relevant emergency service, I know the hospital's across the road, so maybe that's less of an issue for ambulances, but police and fire, just to make sure that they've been properly consulted and are satisfied with the proposals, right, as they stand. So again, if you could maybe just provide, as I say, not necessarily now, but just provide in the course of your evidence gathering assurances in relation to the emergency services. So they were my question. I don't know if Paul is anything you want to say just in response generally to that, but they were points that came up when I was looking at your council statement of case in terms of the justification for the order.
No, thank you very much, Paul. That's very useful, the points you've raised there, and I think taking on board the position that you've said in respect of no surprises, and we'll give you the confirmations that you require well in advance of the hearing. I don't think I've got anything further really to add at this stage.
Okay, thank you. Now, those questions were mainly addressed to the council on the basis of the justification rather than the objections. But I'd open up to Stephen first of all and Fraser on the points that I've just been discussing with council representatives. Is there anything that either of you would want to say on those points? Stephen, first of all.
No comments.
Thank you. And Fraser?
No, not at all.
That's fine. Okay, right. Thank you for that. So that takes us back to item 5 on the agenda, which is documents and preconditions. And my next comments are addressed to both of you, but perhaps in slightly different ways. When we get to the kind of the stage of looking at a date for the hearing, on that basis of no surprises, it'll be important, I think, that we look to ensure that there are lodged with me and sent to all other parties any documents and lists of witnesses and recognition statements that parties wish to rely on. So starting, the documents thing applies to everybody. So if there are documents that objectors want to rely on, and in particular documents that are not, if you like, public documents. So if you want to rely on something that's part of Orkney Island Council's local development plan, that'll be known to the council. So don't worry too much about that. Tell us you want to rely on it, but you don't have to necessarily send it to us. But if there's documents that you want that any party wish to rely on that might not be known to the other, then it will be important to send that and ensure that all parties have sight of it. And the same for lists of witnesses. As far as the objectors are concerned, you're perfectly entitled to just turn up yourself and speak. But if you are intending to bring witnesses along or other people, particularly professional persons, if you have that in mind, you're going to need to give us a list of the witnesses you intend to bring and produce what are called recognitions, which are statements from those people. My practice, and I'm open to suggestions from attendees here, although this is a hearing, I do quite like to get, particularly from the council, if only short recognitions. You haven't even been as long as you want, but I tend to prefer to get some statements from the council witnesses, if only setting out what the professional qualifications are and the topics on which they're going to speak to. And that simply makes it easier for me to make sure I'm directing the questions to the right people. Obviously, Paul, that doesn't apply to you because you're not a witness in that sense. But for your witnesses, if you want to see more than that, obviously that's very welcome because that gives parties notices and notices of what's happening. But I'd be looking at no later than 14 days prior to the hearing for those matters to be produced. And as I say, for objectors as well, objectors shouldn't feel the need to produce witness statements themselves because they can rely on they can rely on the objections that they've lodged already, and they may be subject to question themselves. But if they are bringing or looking to bring other witnesses, then the same would apply to them. And as I say, documents and statements 14 days before the hearing date, and lists of witnesses, obviously that would be useful from that perspective. Which kind of leads a little bit to my next question of looking at in very general terms and in principle, effectively, as to when will be a convenient time to be holding the hearing. I'm conscious that we're not very far away from holiday periods coming up, and hopefully all of us are going to get a chance to get away. What I'd like to go around the room and just invite people to say a little bit about what their thoughts are in terms of preferences to build in time for all these various procedural matters and for us to organise a hearing place and date in Kirkwall. I'll come to the councillor first, but I'll give Stephen I'll say to Stephen, who I'll bring in next. I don't know what the nature of your business is, but I'm conscious, having Googled it, that the Orkney schools, I think, go back on the 16th of August after the summer period. I don't know whether the nature of your business is such that you prefer you and Tracy and others will find greater availability if we try to hold the hearing before the 16th of August. That's not very far away, but if that's a preference, then you can really let me know. But I'll ask the council first of all what their general thoughts are for dates of a hearing. I should say, by the way, in inviting you to talk about dates, I'm not going to hold anybody to anything. If you say this seems fine, and then you go away and find actually it doesn't work for different reasons, then don't worry too much about it. But council, first of all, what are your thoughts on the general sort of time scale of when a hearing might be appropriate?
I think I'll respond first, Jamie. I think in general terms, just trying to avoid the summer holidays would be a good idea. Certainly avoid July, and I think probably sometime, we obviously want the hearing as soon as possible, but perhaps sometime in August, perhaps the 2nd or 3rd week in August, round about there. But welcome to hear what everybody else has to say.
Thank you, Jamie. Is there anything you want to add?
I would agree with that. I think without any sort of undue delay, but August sometime. Bear in mind as well the end of the 2nd week in August. There's one of the local agricultural shows in Orkney, so the council closes on the Thursday, and there's often a lot of folk off on the Friday. So that's a specific thing in the 2nd week. But yeah, August sometime as soon as possible. Okay,
thanks. I'm just bringing Stephen now. What are your thoughts? I say, bearing in mind the potential childminding interaction in school dates.
Yeah, the childminding every day throughout the year. It doesn't close for the summer or anything like that. Okay. For us, July is probably not a good option. So yeah. I'm probably second half of August onwards is fine for us, I would say.
Okay, that's helpful. And Fraser?
From my business point of view, obviously with the visitor season, I mean, for a site visit and things, I would say July would be good. But as far as practicability goes, out for myself, I would say end August, start of September.
Okay. Well, that's very helpful. That's all good. So I will explore options around that to find time to make that work in a suitable way, which is all fine. Thank you for that. Item 7 on the agenda. I mentioned proposed modification of the order, and this is just a flag. It's not a hint. It's not an indication of what I'm thinking in any way. It's just to flag up what I said at the beginning, is that ministers have 3 options. They can confirm or refuse to confirm the order, but they can confirm with modification. I've looked at the planning consent and the layout of the car parking arrangements there, and I can see where the proposed car parks are. But one of the issues that just comes into my mind, and I don't know how feasible it is, but again, it might be useful for the council to think about this in the presentation of their case, as to whether there is any scope, and so I'm not saying there is or isn't, but whether the potential for scope for a modification of the order to provide the same number of car parking spaces while retaining an access along Scapa Crescent, mindful that it's one way, so the sort of road width is such that it doesn't, it doesn't perhaps necessarily need to be closed both ways. Again, I don't need an answer for that just now, but I just flag up the fact that one of the questions I'll need to address is whether, if otherwise satisfied, and approve with modification, and that's probably the only modifications, unless Stephen or Fraser can think of any others between now and the hearing, that's probably the only potential modification. But again, if I could ask Paul to ensure that your witnesses are able to come, able to answer questions about potential modifications. And if anybody has any other modifications, that's only one that came to my mind, then again, it'd be useful to indicate that before the hearing to give the council a proper opportunity then to think about the potential scope for modification. Paul, you want to say anything about that at this stage, or just flag that up as an issue for consideration?
No, that's very helpful, Paul, and that's something that certainly we would have to have a wee look at. But no, thanks for flagging that up.
I expect you to take technical advice on that as much as anything else, because of sort of the space considerations. But just again, on the basis that if it were possible to find a way in which, and I know it would mean the planning application would require to be modified, but that's just it. At the end of the day. But if there weren't a means by which the road could be retained on that basis, I think that's something that I need to at least explore and understand if it's not feasible, what the technical or other reasons from the council's perspective are for not proceeding with that.
Right, that if a modification was allowed, that would allow that section of road to be kept open. We would probably look favourably on that, because we always said we thought the other side of Garden House, that little section of road, would be the better bit to close, because there's a small bit in front of Arcadia Park that could easily be adapted into an extended car park. I'm sure with a wee bit of planning, you would be able to put a road a bit further along there to allow access, kind of in the shape that it's in at the moment, but giving you extra car parking space. So we would look favourably, I think, on that option.
Okay, well, that's a helpful indication there of something for the council to give some thought to, and then ensure that they can consider, as I say, the technical and other aspects of that, so that at the hearing we can explore that properly.
I just say that I would be in favour of that too. I would have no objections if it was moved to the other side.
Okay, well, that's a fair indication there as to something that just to make sure we can be satisfied about from the council's perspective. So thank you for that. Item 8, statements of case. We're happy to see the council take the case. Paul, you're thinking about whether you want to supplement that. If we are looking for a hearing at the end of August, then if you were submitting a statement of case, then again with the school holiday periods coming up and making that a little bit awkward. But once we explore the question of when the hearing date is going to be, then obviously the asking you to get a statement of case in at a point sufficiently in advance of the hearing to allow the objectors, not just those on the call, the objectors to comment on that would be very useful. I'm probably not inclined to think in terms of putting dates on you for that, because you need to think about, as you've indicated, you need to think about whether you want to make further, give a further statement. But if you did, my normal practice would be allowed to objectors a couple of weeks to comment on that. So if you could build that into your thinking of your timings of all of that. And as far as the objectors are concerned, as I said earlier, I'm very happy if you want to do so for you to rely on your objections as submitted without complementing or sort of supplementing that. But if you wanted to submit a further statement of case, sort of in similar style to what the council have done, you're perfectly welcome to do that. And again, if you did that, I'd give the council 14 days to comment on your statement of case. So you each have an opportunity to comment on each other's statement of case. But as I say, don't feel obliged to do it. It's entirely up to you whether you feel you want to do that or not. And that, as I say, will be dictated to a large extent by the timescales for the hearing itself. My last substantive item on the agenda, which is just getting ahead of myself a wee bit, but closing submissions and next steps, just to say to parties that my personal preference on hearings is not to expect parties to be making closing submission on the day of the hearing itself. It's often obviously quite difficult to do that when you've just been hearing evidence for the time concerned, and I would normally be inviting parties to make closing submissions within 7 days of the holding of the hearing. So just to reassure all parties, as part of the formal process of this, that you get a chance to make closing submissions, which can't lead new evidence, but summarises your case effectively. And my intention would be not to have that on the day of the hearing itself, but have it, as I say, within 7 days. And then after that, I will proceed to write up my report. Hopefully I'll have all the information I need for that. I'm envisaging, if it's an in-person hearing in Kirkwall, we'll do the site visit the same day, and then I'll finalise my report to ministers that stage for consideration by them. Paul, do you have any comments on closing submissions? Does that seem reasonable?
Very reasonable. Very, very happy with that. Thank you, Paul.
Yeah, thanks. And again, Stephen and Fraser, I don't know if there's anything you have on those points. You'll have the opportunity as well to summarise your case. As I say, what you can't do is introduce new evidence, but you'll have an opportunity after the hearing to just reflect and see if there's anything you want to say to me that summarises your objection on that kind of basis. You won't get a chance to comment on each other's closing submissions. You just submit them, and that's the end of the process. But do either of you have any comments, Stephen and Fraser?
No, it's fine with me.
That's fine with me too.
That's all fine. Okay, well, that's all fine. That's all good. We've managed to keep ourselves a little bit less than an hour so far on this meeting. I had no other issues from my perspective. As I say, I'll write up some of the action points from this and issue that to all parties. I don't know if anybody else has anything they wanted to raise at this stage. I think I should know about or unclear about in any way. Start with the council.
No, nothing further from myself. Anything, Jamie?
No, nothing from me. No.
Okay, so Stephen?
No, nothing for me.
Yeah. And Fraser?
No, nothing for me.
Oh, that's fine. If anything does come to mind, just email the case officer, Laura, who's been in touch with you. I should say to the objector, it sounds like a bit of a kind of convoluted process that you have to go through in correspondence with a case officer, but that's to ensure procedural fairness so that I don't have any communications with one party that's not in the presence of or made aware to other parties. So it might feel a little bit cumbersome that you have to go through Laura rather than communicate with me directly by email. But that, as I say, that's to make sure that nobody has an access to me as the reporter that other parties don't have. But Laura will be happy to answer any questions, and she speaks to me regularly about issues arising in relation to procedures and other matters. So, as I say, feel free to be doing that. But unless there's anything else, I think I'll just call this meeting to a close, and thank you for your participation today, and we'll get in touch again in due course for further procedure. Thank you.
Thank you.
Thank you.